Good evening, everyone. Can you hear me? Good evening, Osuji Chika. Uh, the person using iPhone, please kindly rename your Zoom. Kindly change it from iPhone to your name so that we can identify you by your name. Good evening, Ezine, you, Olabiye, Miriam. How is your day? Can you hear me? No one is responding. I don't know. You guys should respond so that I will know if you can hear me or not.
Good evening. I can hear you.
Good evening, Mr. Hussein. Can hear you.
Okay. Thank you very much. All right. From my time, I can see it's 5 o'clock. I don't know how what it is in your time, but I think we can start right now. Um, and I can also see one of our mentors is on the call, Mr. Emmanuel Ewewe. Good evening, sir. Welcome to the call. All right. Thank you very much. So
Thank you
my
very
name is
much.
Hussein Mahadi, and I'm the moderator for today's session on data privacy and protection on Gypsy Mentorship and Internship Program, week 1 of the third quarter of 2023. And our topic for today is Introduction to Data Protection and Privacy. We have two mentors for today's session, Mr. Emmanuel Ewiri and Mr. Solomon Okedara. Mr. Solomon Okedara will be joining us soon. I'll be making a few announcements before I'll give the floor to our mentors to give us an overview and introduction of the topic. Afterwards, we'll be taking mentees' presentation and also the question and answer session. So kindly permit me to share my screen and also make few announcements and also read our mentors' profile for today. Okay, I hope you can quarterly program for students and young professionals across Africa. That's about the program, about Gypsy Mentorship and Internship Program. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forum, industry updates, and resource materials from experienced mentors. The program seeks to encourage continuous development and evolution in Nigeria, Africa, and around the world. You can watch most of our videos on YouTube, Facebook, LinkedIn by searching for the word JIIPC. Some of the objectives of the program is to provide easy access, guidance, training, and resource material for students and young professionals in Africa and around the world, to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, and to transform mentees into mentors and leaders to the next generation. And finally, to facilitate further mentorship, internship, scholarship, and job placement for the mentees. So I'll be moving on to reading our mentors profile for today. The first mentor for today is Mr. Emmanuel Ewewe. Emmanuel Ewewe is an information technology law specialist with years of experience advising clients on a wide range of legal issues related to technology, including ICT contracts, data privacy, cybersecurity, intellectual property, and e-commerce. Skilled in drafting and negotiating contracts, he's providing risk assessment and resolving disputes. That's the profile for our first mentor for today. Welcome once again, Mr. Emmanuel Ewewe. We are so happy to have you on the call with us today. I'll be reading the profile for our second mentor quickly so that we can jump into the main program for today. Mr. Solomon Okedara is a barrister and solicitor for the Supreme Court of Nigeria. He is a practicing legal practitioner researcher with over 14 years post-law experience and outstanding expertise in human rights, with a special bias for digital rights, including data protection and privacy, digital identity, online expression, intellectual property, e-commerce, tech, and corporate transaction. Corporate transaction, okay, and artificial intelligence, having an unusual knack for excellence and matchless client satisfaction with a view of deriving maximum results, armed with a peerless ability to in creative legal research and analysis, delivering impressive results in review of law, legal principle, and standards. Mr. Solomon is a partner at Solomon Federal and Co., a firm of barristers and solicitors, and co-founded Digital Rights Lawyers Initiative. A non-for-profit NGO that focuses on promotion and protection of digital rights. Solomon is a strategic litigation lawyer with a robust interest in and proven expertise in freedom of expression and digital rights litigation. He has litigated on digital rights and freedom of expression subject in courts across Nigeria up to the Supreme Court, and he has conducted cases at the ECOWAS Court, among others. Solomon was in 2020 recognized as one of the top 50 individuals leading in legal innovations in Africa at the African Legal Innovation Award. Solomon currently serves as a legal researcher with Columbia University in the city of New York for the Ivy League Schools Global Freedom, bordering on freedom of expression subjects covering over 120 jurisdictions across the world, including the United States, Europe, India, and Africa, among others. He is a 2016 Research Fellow recipient of International Center for Not-for-Profit Law, ICNL, Washington, D.C. He was specially recognized in 2017, Hero of Human Rights by Access Now. Solomon was specially recognized as a finalist at the 2018 Global Freedom of Expression Prize of Columbia University. Thank you very much for joining us also, Mr. Solomon, if he's on the call right now. Those are two mentors for today. We look forward to. Okay, I'll be giving all the floor to Mr. Emmanuel Iwewe to start with his presentation on the topic for today, Introduction to Data Protection and Privacy.
Thank you very much for having me today. It's a great pleasure to join the house and also to be a mentor. And it's also beautiful to have Mr. Solomon. And I believe that with our guide, you will be able to gain a better understanding of what you have studied about and made out a presentation on. So I will just share a brief history on the background on data protection law. Now, back in the 1960s, when the introduction of computer systems became really, really massive, and the use of personal data increased as well. This gave birth to a great concern on how they can protect the potential misapplication and unauthorized use, access of data. Now, this necessitated the implementation of several regulations and also safeguard to this data. Now, looking also at the evolution of how data protection legislations started coming about. Excuse me. Now, we see that most most data protection and also privacy have been captured by countries, and this is contained in their constitution. Now, looking at Nigeria as an example, the 1999 constitution has in it, that's section 37, 38, and 39, which actually provided for the right to privacy, the freedom of thought, conscience, and religion. Now, this vested to Nigerians that the right to privacy. So long before now, we already have a law. We already have it right in our constitution, the right to privacy for our data subject, which lacked certain form of enforcement. Now, let me continue on how the evolution of these legislations came about. Now, these laws were in existence, but they were on privileged grounds. Then we look at other countries. Now, apart from Nigeria, we look at other countries like the United States. Back in 1789, yeah, the United States had this Bill of Rights. And in that Bill of Rights, it actually provided for rights where an individual will have that security to their person, to their homes, to their documents, and also prevent any form of unnecessary search and seizure, just like what we have in Nigeria. I will share examples. We have where a policeman will meet an individual, he will collect the person's phone, search it, and want to see how he can get incriminating evidence against that person. Now, this is actually a violation to the person's privacy. So back in 1789, the United States already had this Bill of Rights where there was a strong prohibition to this form of unwarranted search. Now we look back also to the EU. The EU back in 1995, they already had the adoption of the Data Protection Directive, where they were able to create a standard for data protection regulation. And now in 2018, they brought about the GDPR. And this regulation helped the whole of the EU to ensure that the respect of privacy and data protection was top-notch. Now, I'll also share something very, very. I'll share a little story about. There's this part of data protection I really appreciate so much. There's this this American scholar that wrote a book, that wrote an article back then, I guess in the 1970s or so. Yeah, he wrote an article, Samuel Warrant. Yeah, they wrote an article on the right to privacy. And in that right to privacy, they defined privacy as the right to be left alone. So as a student, just imagine the right to be left alone. Now, this will give you a very, very big, wide understanding on what privacy is all about. Now, they went further to explain more on how relevant safeguard data protection is very, very essential. Then we come back to the United Nations, where the Declaration of Human Rights has a landmark provision for the protection of privacy, for the protection of privacy. Now, coming back to Nigeria, on the 14th of June, the Nigerian Data Protection Act was passed, and this gave birth to an enforceable system whereby the previous regulation was now given that power of being enforceable. Now, this came with a lot of rich packages, and I believe that in the course of our studies today, and also and our program today, you will get to understand more about it, because we will share more light about it, and we will answer questions in regards to this aspect as well. So this will be all for now for me, and I'll be back again. Thank you very much.
All right, thank you very much, Mr. Emmanuel Ewewe, for that wonderful introduction of the topic and clear explanation. I'll be giving the floor to our second mentor for today, Mr. Solomon Okedara, for his own speech on the topic.
Okay, so good evening, everyone, and it's great to be with you guys once again. By the way, I actually almost missed this session because for me, I wasn't too quite sure I'll be able to make it. And but then one thing led to the other, I realized I have to be here. And by the way, I think I have two options. Can I actually go on without my video, or I have to leave my video because I'm sure you cannot see me. I mean, the lighting here is terrible. I'm not home, so I'm sorry about that. So which one do I do?
So we prefer to be seeing you like this.
Okay, great. So yes, the first thing is that I think this will be the first mentoring session we're going to have after the enactment of the Nigeria Data Protection Act. Finally, I mean, for me, it was an exciting day when we realized that we now have a Data Protection Act. So why is it exciting? It's exciting because this is the first time we're going to be having a comprehensive legislation on data protection. Yes, we have had NDPR, and I think some of us have actually litigated data protection based on that regulation. In fact, at DRLI, we have litigated up to the Supreme Court on NDPR. But then the challenge here is this. Oftentimes, some data controllers, or particularly public data controllers, those are ministries, departments, and agencies of the federal government, are not even complying with that regulation, which is so sad. But right now, we are, because some of them, their issue is that, look, NDPR is a subsidiary legislation of an agency. No feigning ignorance of an act of the National Assembly. So straight into the business of the day. When we are talking about data protection, we understand that the class of data we're talking about, are personally identifiable information. Your name, your phone number, your email address, your photograph, your BVN, your NIN, any kind of number or any kind of personal data that can directly or indirectly identify you. Those are personal data, right? So when we're talking about data protection, there are some basic terminologies we need to understand. One, data subject. Data subject is a person to whom personal data relates. Now, Solomon Okedara's phone number is a personal data for Solomon Okedara. Now, and Solomon Okedara is the data subject, only that phone number. Now, number two, data controller. Data controller is the entity responsible for processing personal data. Let me clarify. Your university is a data controller. Your employer, a law firm, a bank, is a data controller. Your telco is a data controller. Your bank is a data controller. Any entity that has responsibility for processing your personal data is a data controller. It could be a private data controller in the cases of telco, banks, and some other institutions, and it could be a public data controller in the case of a state university, federal university, or offices of the government. Then the next one, what amounts to data processing? Now, let me clearly at this stage distinguish between data processing under data protection regime from data processing when it comes to computer applications. Now, I know some of us here at some time or the other, maybe in secondary school, we actually take some basic courses in data processing. That's different from what we are talking about here. Data processing here, it's about the processing that include dealing of any kind with personal data. Now, recall that if you have taken any basic course in computer data processing, we are talking about inputting information in the computer. And those information could include personal data and non-personal data. But when we are talking about personal data, in this instance, we are talking about personally identifiable information. For example, for getting information as personal, right? Public information do not qualify as personal data, but your name, your email address, your BVN, your Twitter handle, your hen, all of them qualify as personal data. So any process that involves dealing with them, collection, storage, categorization, transfer, even deletion. For example, when you need to open a bank account and the bank gives you a form to fill. Now, in that process, the bank is collecting your personal data, then it's processing it. Now, when the bank stores your personal data, it is data processing. When the bank categorizes your personal data, it's processing. When the bank transfers your personal data from BV, there's some purpose there that some loans, some micro loans from micro digital lenders, like Fair Money, like OPay and all of that. So when you are owing Fair Money and OPay gets your money, that's actually about data portability. Your data is moved from one, because if one institution does not move your data to the other, then they cannot access your money in the other bank. So data portability is a form of data processing. And in fact, deletion of that data is data processing. So these are basic terminologies we need to understand. So I did mention of personal data. What is personal data? I did mention of data subject. I did mention of data controller. And of course, I did mention of data processing. Then there's something called data processor. Sometimes a data controller hires a data processor to process data on his behalf. So let's imagine a situation, even NIMC, for example, when NIMC collects your data, NIMC has some technical partners, some IT firms that get involved in processing your personal data to give you the NIN, which is the overall results. Now, such institutions or such companies are data processors. Let me simplify it. So we have Isaac Udo. Is Isaac in the room? Isaac, are you in the room?
The room. I'm in the room. I can hear you.
Great. So Isaac and Chika, they actually enter into a contract. And the contract is that, look, you need to build. Isaac actually wants, Isaac lost money. Everybody who knows him will know that he lost money. So I actually got a contract, from let's say from Microsoft. So Microsoft wants to know the number of MSMEs in Nigeria, or let's say in Lagos, that use Microsoft applications. So now Chika has run a small startup, that is so versed that understands the nitty-gritty of the use of Microsoft applications by basic phone owners around the country. So, and as a team that understands the terrain. So now in that situation, Udo, Isaac, now hires Chika. Okay, Chika, I want to hire your friend to go on the street of Lagos, get MSME owners who use Microsoft applications. Then we need their number, their name, how often they use these applications, and Now, hello, can you hear me? It seems you guys have lost me.
for a minute. So I think your network is fluctuating.
Because
I don't know if I'm the only one. I think
I'm not home, so I would have been using actually in the webinar. Can you hear me, guys?
Yes, we can hear you.
I'm sorry, the call came in again. So now Chika approached. So Chika went on the street, and Chika and the student went on the street, and they began to gather data, personal data, phone number, email address, and all of that of MSME holders. Now, in that situation, can somebody tell me, we have 3 categories of persons. We have, so tell me who we have, their role, and their identity under data protection regime. So let me go back to Isaac. Isaac. Isaac, can you help us out? You got the contract, and we are asking you to defend your paycheck. You disappeared.
My line was breaking. I can hear you.
Okay, it's all right. So now you got the contract from Microsoft, and you employed Chika to go on the streets of Lagos for the research. Now I have asked you. Now, so we have been set up as a team of a panel of. Oh, I'm sorry, guys. I'm not home. So, but can you hear me now?
Yes.
A panel of inquiry an independent panel has been set up, headed by my humble self and Mr. Emmanuel. So we really want to know whether they actually gave the job to a competent hand. So who are you? Who is Chika? Who are those MSME owners in the data protection ecosystem?
So I didn't get your example clearly. I don't know if you can just run through it.
Isaac, you got a contract from Microsoft. I'm sure you did not disclose to anybody. You don't want them to hit or chop from your money. That's fine. Now, you went ahead to talk to Chika. Chika runs a consulting firm, a research firm. Now that actually the coverage of quite MSME owners around the country. Now, MSME owners that use Microsoft applications, and Chika has agreed to run that process for you, to interview them, to gather their personal data. So we are an investigative committee or panel has been set up, headed by myself and Mr. Emmanuel. We are now asking you, in data protection ecosystem, who are you? Who is Chika? Who are those women, the MSME owners? Identify them, please.
Okay. In that scenario,
yes,
I believe since the employer in this case is, I believe I should be the employer since I'm the.
No, I see do this now.
The Microsoft organization, sorry, is the employer. Can you hear me, sir?
So you're not the level of class.
Can you hear me, sir?
I can hear you, but you are not eating on what I want you to hit on.
The question being asked.
In the room? Is Chika in the room? How many persons are in the room today? I can't see anybody. Do we have Miriam in the room?
Chika, are you not there?
We are here, sir.
Okay, are you Kosola, right?
I'm
Yes,
here. Hello, sir. Are you there?
Did you listen to the question? I'm here. Are you Kosola?
Yes. I think for the NMR, I think they are the data subjects.
Okay.
Am I correct?
Then
I think
me.
I think Chika is the data.
Mr. Amanda, I cannot tell you we are on the panel.
So, okay, for The NMR women, I think they are the data subjects, and
Okay.
Chika is the data processor.
Okay.
Who am I? What's that person's
No,
name?
you're not there. You're not there.
I mean,
not
the
there.
guys
So-
you mentioned just now.
So Isaac is the only person left now.
Okay. Is IT not the? I don't even know.
Oyinkansola, don't do this. Oyinkansola, don't break my heart. Don't break my heart.
Sorry, sir.
Don't say you see not. No, just tell us whatever you know. Listen, guys, this class, don't be afraid to get it wrong. Right. Please don't be afraid. In fact, when you want to get it wrong proudly, the best is you are wrong. And you go with answers. And the way you get the right answer, you know if you have known it. That's fine. So who is Isaac?
I feel like Isaac is data controller, sir.
Okay. Thank you. Thank you.
Yes, sir.
Whether you get it or not, you will know, and we'll let you know at the end of the meeting.
Right,
yes. But thank you for a good try. Isaac, are you back in the room? Somebody collected money. He chopped the money. He ran away. Chop alone. Isaac.
So my line is breaking. My network is bad.
Your network will break. You have collected money. Your network, before you collected money from Microsoft, your network wasn't breaking. You are sending email to them. They will reply your mail. They process the money. They disburse money. Your network wasn't breaking. Isaac, you have forgotten what they always say, that chop alone, die alone. It is well. So, Mr. Emane, did Oyinkansola got it?
Okay, first of all, I'll have to commend her braveness coming out to speak, even though we have those that their network was failing. And
Yes.
It's good to note that she was able to identify a data subject.
Great.
And so I believe that the example was really clear enough for anybody to be able to learn the basic terms.
Yes.
In this field. It is very important to use the very language, not using an employer. So
yeah, thank you.
Now she also made mention of Chika. Now Chika is okay. Let me share more light on this example so that let me expand it, Mr. Solomon. I think it would be interesting to expand it this way. Now Chika got a contract from Microsoft.
No. Isaac got the contract. So
okay,
Isaac
got a contract from Microsoft. So Isaac has been okay. Now in this form, Isaac is actually in a position that you can also see him as a controller and also a processor.
Thank you.
So Isaac getting the contract from Microsoft makes him a processor because Microsoft will be giving him the directive on data to work on. So he is acting under the act and direction of somebody. Who is that person? Microsoft. So Microsoft is the controller, while in that position, Isaac is a processor. Now, Isaac is also sub-delegating.
Yes.
So in that instance, being in that position of sub-delegating his job, he is actually acting in the capacity of also a controller, and those persons he is actually delegating those powers to are the processors because they are working under his control and directives.
Excellent. That's a very robust intervention. That's very robust. Thank you so much. But trust me, will you say Oyinkansola got it?
That's why, first of all, I had to appreciate her bravery coming out.
So Mr. Emane, so she got it. The only thing is that it could be more, right?
Exactly.
Thank you. Oyinkansola, are you still in the room?
Yes, I'm here, sir.
Please just take a bow, take a bow, take a bow, take a bow.
Thank you so much, sir. I'm grateful, sir.
Oh, Mercy, chop donkey, chop donkey. Mr. Abena, please give her one up. Let her chop up. Give her one up now. Okay, great. So I think we got that covered. So let's move on to the basic principles of data protection. Now, generally, of course, let me say this. Generally, the number one principle I want to talk about, generally, in some jurisdiction, it's not recognized as a principle. But then, okay, so yes, it's a principle. Yes, I'm trying to make it up for right. So it's a principle, but oftentimes it's not seen as a right. But under the Nigeria Data Protection Act 2023 is a right now. GDPR as a right, but it's treated as a right under the NP. So it's consent. Consent says when your personal data will be processed, your consent needs to be sought and obtained. When anybody needs to collect your phone number, store it, categorize it, use it for any purpose whatsoever, they need to get your consent. And this consent we're talking about, there have been some decisions, of course, that the consent has to be credible and positive. What does that mean? Under no circumstance should the data subject be left in a situation where he is guessing, he is unclear, is in doubt as to whether he or she gave consent to personal data to be processed or not. So what that means is that it must be in such a way that it is clearly distinguishable that consent was given. Number two, lawfulness. Now, that lawfulness in one breath has subcategories, and in another breath, it actually dispenses with, it can dispense with the requirement of consent. I'm going to give an example. If, for example, a law provides for processing of your personal data, in that situation, your consent may not be sought nor obtained before your personal data is processed. There are many examples to that. Even your NIN, it is by law that your personal data will be processed for NIN. So that dispenses with your consent. Many of us here can come up with a number of examples where the law provides for your personal data to be processed, and it doesn't have to be for registration, that you need to tip this, you need to do that, then consent may not be required. So the lawfulness, if myself and Oyinkansola, Isaac, I don't know whether Isaac has come back to the room, maybe he has contract this morning, so he's waiting for another contract. So myself and Oyinkansola I enter into a contract, and I now have to send a mail to Oyinkansola to perform a particular contractual obligation. Does that sending mail qualify as processing our personal data? Yes or no? Miriam, are you in the room? Isaac, are you back? Isaac.
I'm here.
I know you are here after you have spent your money alone. Like I told you, always remember, chop alone, die alone. So myself and the contract we had, and I want to send Oyinkansola an email, an extensive email for a contractual obligation to be performed. Will you consider that the email I want to send as processing our personal data? Yes or no?
Yes.
Yes. Why?
In this case, I'm dealing with the data in a way I'm transferring it. So it's basically processing.
Okay. So in this case, because I am dealing, you are not you now, it's me now. Why are you? This is not guy. So I sent our email using our email address. Correct. So in that case, I processed our personal data. So, but then do I need to seek a consent to process that, to send out that email? Isaac,
Yes, sir.
do I need to seek a consent to process that personal data by sending her that email?
Yes, you need to.
How? How will I see that consent? I'll send that email to tell her I want to send that email.
Okay, you are sending an email. Hello, sir.
Hello, I'm saying, how would I see? You said I need to seek a consent to process our personal data in performance of an existing contractual obligation. Let me make it clear. Myself and Oye Consola met last week. We signed the contract. We signed the contract.
I think that the fact that she has already agreed to a contract is an implied consent and has waived that waived the secondary consent that she would need to give to you sending her an email in regards to the contract she has agreed to.
Okay, good. So you got it because it's actually in performance of a contract. So in that situation, it dispenses with the need to get a consent. Because in any case, let me ask this question. If I need to get a consent again to send her a contract, to send her an email, how will I seek how will I seek that consent? How? Can somebody tell me? Is Ngozi in the room? Okay, please.
You need to still transfer her data by either calling up her phone number, that's using a service provider, or sending an email. So using
that
a data
still have to process our data. We take a consent that I want to process our data. Do you understand? Hey guys, are you following?
Yeah, yeah.
So in performance of a contract, then an existing contract, then I don't need to seek a consent to process it. And there's some other situation, a lawful obligations, order of a court. For example, if a court serves an order, I always love to give you an example. If now that ISIC has blown up the money, and I remember that he was owing me some 500,000. Now, so I've sued him. Now we went to court, and the courts have given. So Inkosola is actually not Inkosola. It's not a judge. Let me look for the judge here. So Amina is the judge. No. Sorry. Is Chijioke in the room? Chijioke, are you in the room?
Yes, I'm here.
Okay, so Chijioke is the judge, and she gave a, what is it called? A judgment that, look, truly Isaac is owing Solomon. Now, somebody here is the legal department head of the bank where Isaac has gone to keep the money. That should be, yes, Chika. Chika is the head of the legal department of the bank where Isaac has gone to keep the money, thinking I will not know, thinking he will just travel to Paris to spend the money and will not give me my money. So all I need to do is to commence a garnishee proceeding against the bank Chika heads. And the moment I do that, and I get a garnishee order, delivered by Chijioke, then I will serve it on that bank. So when I serve it on the bank, then I am saying, please pay me 500,000 of the money held and kept by Isaac in your bank. Now, when you look at that process, let me ask you, will Isaac's personal data be contained on that document, on the garnishee order?
Yes, it will, because it gives the bank access to his funds so that they can pay you, since it's an order of the court.
Yes, it will contain his personal name, the bank accounts, which are all his personal data. So in that case, is Isaac consent dispensed with or not?
It is.
So
Somehow.
why? What is so much? Is it dispensed with or Is his consent required in that case or not? Chijoke, no, the phone my hand now. No, you be the judge. Sorry, I'm speaking
His,
quickly.
his,
Chijoke,
his
you are the judge.
consent.
Chijoke, you are the judge. Is his consent
Yes.
required? Yes or no?
His consent is not required since it's
Excellent.
an order of the court.
Because they're not of the court.
It's an order of the court.
Not
You can't go
required
against the
consent.
order of the court. Yes, his
I see.
consent is not required.
Isaac,
I can hear you, sir.
if you like, go to Zambia Forest. You are paying me my money. My Lord is on the call. My Lord is giving the order. So forget it. So, guys, I believe that's very clear enough, right? Is that very clear enough?
Yes, it is.
Yes,
sir.
yes, it is.
Hello, guys. Is that very clear enough?
Yes, sir. Yes, sir.
Yes,
Okay,
sir.
so let's move on to the next one is purpose specification and limitation. Purpose specification is that whatever, anytime your personal data is going to be processed, the data controller has a duty to tell you that to specify the purpose your data is being processed, and it has to be limited to that purpose. Let me give you an example. I know is Ezine on the call? Is she in the room? Ezine,
Yes,
let me
sir.
have you. Are you in the room?
Yes, sir.
I don't need to ask you whether you like pizza. I know you like pizza.
Yes, sir.
You can see if I start a church now, I'll be making money because I can see. So now, the last time you went into a pizza shop, I won't mention the name of that pizza shop, but you know I know it. So when you got there, the lady asked your yes or no? Is in the answer now.
But please, I didn't get the last thing you said. You said
The last time you bought pizza, you went into the pizza shop and you placed an order and they asked for your phone number. Is that correct?
No.
They didn't ask for your phone number when you went to get a pizza.
Maybe it's not Domino's, sir.
Maybe it's not Domino's. But when you went to Domino's, they asked for your phone number.
So I didn't go to Domino's.
It only happens in Domino's.
Maybe.
But Domino's asks for your phone number.
Okay, yes.
Can you see? You know, I saw it. I saw everything when it happened.
Yes, sir.
You can see you are confirming. Isaac, you are seeing the man you are dealing with. You are seeing the man you are toying with. The man who sees everything. I wasn't there when they went to order for pizza from Domino's, and I know they asked for her phone number. She's here confirming in the public. So, okay. So when they asked for your phone number, did they tell you why? Did you ask them why they were asking for your phone number?
No, I didn't.
Great. So, but did they tell you why they needed it?
No, sir.
Good. So they actually contravened a principle of personal data and a right that you have. You have the right to be informed. So after this class, I don't see a reason why within the next 6 months, you shouldn't be getting paid about 2 million naira from Domino's Pizza. And I'm serious about it. This is all a joke. This is not for illustration. This is real. You have a right called right to be informed. So the point here is this. Ordinarily, that attended to you must specify the purpose for which she was asking for your phone number. So it's called purpose specification. That's number one. Number two, now, when after your order was placed and you collected the pizza, you had the pizza, you went home. After about 2 weeks, they sent you an SMS from Domino's Pizza. Is that true?
Yes, sir.
Isaac, where are you?
I can hear you, sir.
Now, talk with a seer. I'm around there and I know that's this time. Okay, guys, naturally those things happen. So they will send that message. But guys, you know that sending that message was actually a contravention of our rights. Now, and because in itself is a contravention of the principle of limitation, purpose limitation. One, they did not specify. But even after you have specified, they need to limit it to the bounds they have specified. So the best what they do, those who specify oftentimes, when some of those ladies attempt to even be reasonable, they'll say, okay, Sama, we only need to place your order. Now, when they now send you that we now have catfish, catfish pizza. Is that the purpose for which they told her? No. So that fails, or that contravenes the principle of purpose, specification, and limitation. Is that correct?
Yes, sir.
Okay, so let's go on to another principle. There's another principle called PET, Privacy Enhancing Technology. That principle says every data controller has a responsibility, a duty in law to ensure that it stores or saves or secures data subjects' personal data with privacy enhancing technology. What that means is that whatever business they do, whatever facility they have, they need to be sure, they need to ensure that at all times their facilities are equipped with privacy enhancing technologies that will keep your personal data safe and secure at all times. Next one, accountability. Every data controller has to be accountable. Accountable, one, to an independent authority. Two, to a data subject. Now, if your personal data gets leaked, maybe from a platform, whether it's Twitter, Facebook, or any other platform, the data controller under the law has a duty to communicate to Data Protection Commission in Nigeria now that look, some data got leaked from our server that was hacked last week. But please record that because he has a responsibility to install privacy enhancing technology. If that was in place, perhaps there wouldn't have been a breach of their database to have actually leaked your personal data. So, but even if that happens under any circumstance, it has to be accountable to one, the commission, and two, to yourself as data subject. Then the principle of accuracy, yes, accuracy. What that principle says that at all times, they have a duty, data controller has a duty to ensure that your personal data is accurate. Your name, your phone number. There was a case where a lady's occupation was wrongly recorded as prostitute, and she was never a prostitute. She went to court, and the court ruled that, look, her personal data was did not include prostitute. She was not a prostitute. Then the court now enforced her right to data rectification, because it was even after she had actually approached the data controller that please rectify my personal data. I am not a prostitute. I've never been a prostitute, but the data controller did not oblige her. Then she approached the court. Then what other principle have I left out? I've mentioned consent, I've mentioned lawfulness, I've mentioned purpose. Yes, limitation of storage. Storage limitation. Every data controller has a duty to inform look, your personal data will be stored for this purpose, for this time. After this time, we're going to delete it. But if the law says it's going to be stored for life, then so be it. But there must be what is called data storage limitation. In fact, it cannot be in all cases that your personal data will be stored for life. Let me give you an example. Some of you were banking with a bank, and okay, for example, Isaac, are you still in the room?
I am, sir.
Now that Isaac money is going to be given to me, and Isaac is now so mad at the bank, particularly with Chika. Eddie that was a Chika, you can do that to me. And that's it. Chika, look, I don't play here. Look, I want my account closed in your bank. Please. Under 24 hours, I do not want my account to remain. And Chika is still trying to persuade him, but he's not ready to listen. Now, at the end of the day, Chika claims that the account has been closed down or there was no communication. A week after, Isaac still receives email from them, SMS from them. A month after, Isaac is within his right under the law to seek a redress against the bank, because now he is saying, look, you cannot store my data forever, particularly since the purpose of having my data has been determined, effectively determined. I've communicated closing my bank account with you. So there's a limit to how you can store, and today is the end of the storage of my personal data with you. So there's a principle called principle of data storage limitation. So, gentlemen, I think on this note, I want to call it a day where I stand by to take, maybe to have your presentations and of course make any inputs and all of that. So thank you so much for having me. I hope you guys enjoyed it. I hope you were able to pick one or two things. So thank you.
Thank you very much, Mr. Solomon, for that elaborative presentation on the terminologies of data protection and privacy, and also the principles of data protection and privacy. And thank you very much for the live instances and the examples that you used. I personally, for me, I feel like this kind of interaction would make sure that every knowledge we learned here will be stick in our head, especially Isaac that ran away with our money. So I'll be calling on the groups. We have two groups, group 1 and group 2. So group 1 will start their presentation, and you know that you have 10 minutes, so you just be very, very brief. And you can also share your slides while making your presentation. You can see your screen.
Good evening. My name is Ibu Ezine, and I'm the presenter for Group 1. And our topic is Introduction to Data Privacy and Protection, Definition, Laws and Regulations, Key Concepts and Principles. Sorry. Okay. So I'm going to be starting with the meaning of privacy and data protection. So privacy simply means the right to be left alone. Simply means the right to freedom from interference or intrusion. And then data protection is the process of protecting sensitive data of individuals. Sorry. More like safeguarding the personal data of individuals from damage, loss, or corruption. And then in Nigeria, there are various laws regulating the data protection thing. And this is because the government has recognized the potential negative effects of data breaches on the citizens and the greater economy. So in Nigeria, the various laws regulating data protection include 1, the Data Protection Act. So last month, His Excellency President Bola Ahmed Tinubu signed in the Data Protection Act into law. And this serves as the primary regulation for data protection in Nigeria. But however, there are other laws regulating data protection in Nigeria, and it includes 1, the Constitution of the Federal Republic of Nigeria, 1919 as amended. So Section 37 of the Constitution guarantees the privacy protection of the citizens of Nigeria, the privacy protections of the citizens in their homes, correspondence, telephone communications, and telegraphic communications. The next one is the Child Rights Act. So Section 8 of the Child Rights Act guarantees a child's right to privacy, but this is subject to the parents or guardians' right to exercise their supervision. And then the next one is the Consumer Code of Practice Regulations. So the NCC issued NCC regulations, and these regulations require all licensees to take reasonable steps to protect customers' information against improper or accidental disclosure. And then the next one is the Consumer Protection Framework of 2016. So the Consumer Protection Framework of 2016 was enacted pursuant to the CBN Act, and this framework includes provisions that prohibit financial institutions from disclosing customers' personal data. The next one is Credit Reporting Act of 2017. So the Section 9 of this act provides for the right to the data subjects to privacy, confidentiality, and protection of their credit information. The Cyber Crimes Prohibition and Prevention Act. This act requires financial institutions to protect the personal data of the data subjects and criminalize interceptions of economic communications. Then the Freedom of Information Act. Section 14 of this act provides that private institutions are obliged to deny any application for any personal data of individuals unless the individual consents to such disclosure. And then the National Identity Management Communication Act. Section 26 of this act provides that no person or corporate body shall have access to data or information in the database of the Nigerian Identity Management Commission without authorization of the commission. And then the National Health Act of 2014. Under this act, health establishments are required to maintain health records of every user of the health services, and also to maintain confidentiality of such records. Then the National Communications Commission Registration of Information Subscribers Regulation of 2011. Section 9 and Section 10 of the regulation provides confidentiality for telephone subscribers' records that are maintained in the NCC Central Database. So we are going to be looking at the different laws regulating data protection outside Nigeria. The first one will be the General Data Protection Regulation, that is the GDPR. So the GDPR simply is the regulation that simply regulates data protection for the countries under the EU. It simply stipulates how the personal data of persons that are residing under in countries in the European, it simply stipulates how the personal data of persons that are residing in countries under the EU are to be processed. And then the laws in the United States. So in the United States, there are various laws that regulate data protection. And these laws include the Children's Online Privacy Protection Act, the Health Insurance Portability and Accountability Act, Electronic Communications Privacy Act, Video Privacy Protection Act, and the Fair Credit Reporting Act. Then under data protection, there are certain key concepts that are actually necessary to understand for someone to be able to understand the field of data protection. And it includes one, the data subject. So a data subject simply means a person to whom personal data relates, more like a person who to which a person who can be identified by certain personal data. For example, more like everyone on this call is a data subject. And then data protection audits. It is a report that is required to be filed by any organization or person that processes personal data. And then data controller. So the data controller simply means a person who determines how and when the personal data of a data subject is processed. It's simply a person who controls, who determines the purposes and the manner in which the personal data of a data subject is to be processed. And then the next one is the data processor. So the data processor simply means the person who processes the personal data of the data subject. So an organization can as well be a data controller and a data processor. And then the next one is data protection compliance organizations. They are licensed professionals that provide auditing and compliance services for data controllers, such as submitting a data protection audit report on behalf of the company that processes personal data. And then to the principles of data protection. So under the Nigerian Data Protection Act, there are certain principles that are stated that are more like principles of data protection. And the first one is lawfulness, fairness, and transparency. So when a company or where a data controller is processing personal data, they are bound to process the personal data according to the lawful basis for processing data that are listed in the Nigerian Data Protection Act, and it includes consent, legitimate interest, contract, legal obligation, public tax, and vital interest. And then fairness. The data controller is to process the data according to the method in which it's more like informed the data subject that the data is to be processed. And then transparency. The data controller is bound to be transparent while processing the personal data. And then purpose limitation. The personal data collected should only be processed according to the purpose to which the data controller communicated to the data subject. When there is need for further processing, the data controller is bound to inform the data subject to elicit consent from the data subject before it further processes the data. And then the next one is data minimization. So while collecting personal data, the data controller is bound to collect the minimum, more like the minimum amount of data that is necessary to perform that particular task. The data controller is only supposed to collect the necessary data in relation to the particular processing, in relation to processing the data of the data subject. And then accuracy. The data controllers are bound to ensure the accuracy of the personal data of the data subject. They are equally bound to more like keep the personal data of the data subject that they have up to date. And where the personal data is incorrect, the data subject can actually correct the personal data that is in more like the storage of the data controller. And the next one is storage limitation. So the data controllers are bound to retain only the necessary data and in accordance to the time limit that was specified to the data subject. It's more like the data controller is not supposed to retain the personal data of the data subject longer than the time limit that was communicated to the data subject. And then integrity and confidentiality. The data subject is bound to take the necessary technical and organizational measures while processing the personal data of the data subject. The data controller is bound to process the data in a manner that ensures the appropriate security and confidentiality of the personal data of the data subject. And then lastly, accountability. So the data controller is responsible for whatever damage or whatever breach or whatever that happens to the personal data of the data subject that it has in its storage. Thank you.
Thank you very much, Ezine, for that presentation. I think it is very brief and very informative. Thank you very much once again, and also to the group members that made the research and compiled the presentation. I'll be calling on the second presenter quickly due to time. So you can start your presentation now. Kindly note that you have 10 minutes also.
Good evening, everyone. My name is Lillian Uzamaka Olelewe, and I'm the presenter for Group 2. And our topic is Introduction to... Can you hear me, please? Confirm.
Yes, we can hear you.
We can hear you.
Okay, thank you. Our topic is Introduction to Data Privacy and Protection, Key Principles and Concepts. So permit me to share my screen. Can you see my screen, please?
Yes, we can see your screen.
Okay. Thank you. All right, that my face shows. Please, my apologies. So today is my sign out. So I just finished my exam, my final paper. That's why I'm in this state. As if I'm not prepared, but I am.
Congratulations.
Thank you. Thank you. And I'm using my phone, so I'm really sorry. So our topic is Introduction to Data Privacy and Data Protection, Key Principles and Concepts. So basically, data privacy is something that is considered very, very technical in today's world, especially in the Internet of Things. And we understand that for every business to thrive, that they need customers, right? And they need the information or the data of customers to thrive, for them to be able to carve out how to progress their businesses. And as a result, it has occasioned a number of suits, a number of cases where customers get to complain that their data is being leaked, information that they stored in secured platforms are leaked and all whatnot. So today's technology is anchored majorly on the collection, use, management, and disposal of data from telecommunication companies to online stores and medical practices. So there's a crazy scramble for data. This is because it allows each of these organizations and businesses to focus their attention on a specific group of persons who potentially would require certain services. So now, this raises the issue of how this data is collected, the right of an individual as regards the collection, use, and storage of the same. An individual can consent to giving their personal information from a medical app, and this data can end up in the possession of a pharmaceutical company for directing marketing. So the protection, data rights, right? The protection of data and privacy stems from the fundamental human rights provisions in Chapter 4 of the 1999 Constitution, specifically Section 35 rather. So the right to privacy stems from that particular fundamental human right, and as a result, that's become something that is key for businesses and organizations alike to thrive whenever they want to progress. So what is data basically? Data has been described as individual units of information which may be measured, collected and reported, stored and analyzed. Data is simply processed information, bits of information stored and kept in an intelligible form. Data is considered to be the oil of the digital era. This particular phrase now is something that has been ongoing. I mean, a lot of persons have been saying data is the new oil, data is the new oil. So data basically is Please confirm that you can still hear me.
Yeah, we can hear you now.
We can hear you now.
About that. So I was defining what data is, and I was trying to draw an analogy between a person who signs up into a social media platform and is required to fill in key information about oneself for the person to be able to enjoy that social media platform maximally. To the business, right? To the organization, they need this data. They want to collect this data to know how to faction that particular user or consumer of that platform. But then to the end user, he is very sensitive in releasing his information out there. And we know that I mean, it's rational in human beings that before you can release your information or data anywhere, you have to be very careful, especially when it has to be do with sensitive information like your credit card information or your date of birth or something that has to do with properties that you own. People are very sensitive to release this information. So there's this balancing of interest between the organization that requires this data from individuals to thrive and these users that are reticent towards releasing their information out there. So now, what is data protection basically? Data protection refers to the safeguarding and preservation of personal or sensitive information from unauthorized access, use, disclosure, alteration, or destruction. It involves implementing measures and policies to ensure that data is handled securely, respecting individuals' privacy rights and maintaining confidentiality. Stemming from, like I've mentioned, from the fundamental human rights guaranteed to all citizens to enjoy right to privacy, right? And one of them is data privacy. So balancing conflicting interests now. Individuals want to ensure that they don't release sensitive information that may harm them in future to all these platforms. The same way, organizations have to be very careful to protect the data of these individuals so that they will not, bring upon themselves lawsuits upon lawsuits. And that is why if there is, especially where in businesses or economy where, these organizations work hand in hand, like when they work hand in hand, say for instance, an online selling platform will also have to key into an organization that provides payments. Say for instance, Jumia will have to key into Paystack, for instance. These are two organizations. And when the information of one of individual is being stored on Jumia platform, they have to exchange this information with Paystack and vice versa. So this exchange of information has to be protected so that it will not land in the hands of unauthorized users, and then they will now use it to be defrauding people. And that's why we always see weekly newsletters or monthly newsletters of our banks always reminding us via mails, via text, that you should protect your personal information because it can be, hackers are prone to getting this information. Please confirm you can still hear me.
Yes, loud and clear.
Thank you very much. So how does data protection work? An example of data protection can be seen in the context of an online shopping platform. I mentioned that earlier. When customers provide their personal information such as their name, address, and payment details, the platform has a responsibility to protect that data. This entails implementing robust security measures such as encryption and secure data storage to prevent unauthorized access or data breaches. So this is the responsibility on the part of the organization or business to protect the data gotten from their consumers or users so that it will not get into the hands or fall into the hands of unauthorized users to now, defraud the individuals or their consumers. I mean, alternatively too, some of these businesses are also prone to attacks, and as a result, people lose confidence in their platforms, and they would give negative remarks, and then it will run down their business. So, what is data privacy? Data privacy refers to the right of individuals to have control over their personal information and to ensure that this information is handled in a confidential, secure, and lawful manner. Now, the key words are in a confidential, secure, and lawful manner. It involves protecting sensitive data from unauthorized access, use, or disclosure, and respecting individuals' rights to know how their data is being collected, processed, and shared. Now, a very good analogy would be, I take myself, for instance, whenever I sign into, or whenever I'm using the Google Chrome browser, and I sign into a particular website, there is this notification that pops up. It's called cookie notification, right? So cookie notification, they bring it up and say that there are some platforms or there are some websites where I have to accept all the cookies. So now cookie notification is a way of data sharing between these websites, whether they are secured or not. So if I accept all the cookies involved like that is used to protect data in that particular website, it means that I'm authorizing that website or that site to get hold of my information and use it to maybe process my demography or something that is going to make their business to flourish. So now I'm very careful to I don't know if I'm getting this analogy correct, but that's my personal observation. I'm very careful to accept cookies that pops up whenever I'm in a particular platform. I'm very careful. Sometimes I reject all, and then I'm not able to use that site or sometimes I manage cookie setting. And it can be very, rigorous, going through all the whole provisions on managing cookie settings and all whatnot. And yeah, that's basically that's on my own part as a user and as an individual, right? Same also, these platforms have to, provide a very detailed explanation on how they require your data and what they will use your data to do, and also to give you assurance that they will take measures. They will take preventive measures for making your data to leak to the public. So it's like a two-way thing. While the individual has to also take preventive measures, the business as well. So now, how does data privacy work? Imagine you sign up for a social media platform. Data privacy ensures that the platform collects only the necessary information required for your account creation and provides clear information about the data it collects and why. It also ensures that your data is securely stored and the platform takes necessary measures to prevent unauthorized access by hackers or any misuse of your data. So that's the analogy I gave earlier. So now we move on to the principles of data protection and privacy. Please confirm you can still hear me and see my screen.
Yes, we can hear you and we can see your screen.
Okay, thank you. So principles of data protection and privacy. One is consent. Obviously, every platform requires the consent of their users or consumers to utilize their data. Once the page where you have to input your data comes up, you can decide not to input your data. That's like an alternative to consent, right? When you start typing in your information, your demography and all whatnot, it's assumed that you are impliedly consenting to them handling your data, right, on the part of the individual. So as a result, Section 27 of the Nigerian Data Protection Act provides that the burden of proving such consent is on the data controller. Now, that is on the part of the platform. So they also have a responsibility to ensure that this particular consent you're giving is not misused or mishandled. Another principle of data protection is security. Considering how sensitive personal data is, its security is paramount against leaks, breaches, modification, or loss. The data controller and data processor therefore bears the burden of ensuring the data stays uncompromised. Section 40 of the Nigerian Data Protection Act 2023 provides that the data processor is mandated to notify the data controller or data processor that engaged it of the nature of the breach and respond to all information requests from the data controller or data processor without delay. Where the breach is likely to result in a risk to the rights of individuals, the data controller is to notify the data processor. So now, basically, security is the principle of security in data protection and data privacy is on the part of the platform, guaranteeing that this particular information that you are providing as an individual or as a user will stay within them, and where in any case they have to share with another platform, they ensure that other platform they are sharing it with is secured. We also take adequate measures to ensure that the security of the data of their users is ensured. So now the third principle is fair, lawful, and processing. Data should be obtained with consent of the individual, limited to necessary data, and for the purpose for which it was processed. This is something that has been a technique used by all these organizations. They don't require information about individuals that are obtuse or information that will not help them in any way. They are very particular about the information that they require, and that's why they use this information to streamline their area of businesses. The fourth one is data minimization. A data controller ought to collect and process only the data necessary for the particular purpose and nothing more, especially not even anticipator. The fifth one is accuracy. Accuracy of the data should be achieved completely and up to date. The sixth one is storage limitation. It is to be kept only for the period required to accomplish the purpose. Now, this is, I don't know, personally, I feel this is something that some of these platforms, they default in. If you are supposed to hold the data of a certain demography for a particular period of time, some of these people, they don't completely erase the data when they are done using the information that they've gotten, right? So it's like a shortcoming on the part of some of these platforms. The seventh principle is purpose specification. Data is to be collected for specified, explicit, and legal purposes. That's what is contained in this very long requirement that some of these platforms, they pop up and say that there's this box that will say, I consent that I've read all the requirements for the use of my data and privacy. And when you tick that box, rather, it's assumed that you have consented to all of these things when they've listed all the purposes for which they need the data for. Then the last but not the least is accountability. The data controller owes the individual whose data is collected a responsibility to process the data in a transparent and lawful way and with respect to their rights. So these are basically the principles of data protection and data privacy. So in conclusion, even though we understand that data is the new oil, because some of these platforms or some of these businesses and organizations use it in such a way as to promote their businesses or ensure that they have adequate, adequate preservation for their businesses. It can be a downturn where some of these organizations are hacked or they are compromised, or the data of individuals that are stored in their system are compromised. And there are various number of lawsuits out there where individuals are trying to enforce their right to data privacy against some of these multinational enterprises. And I mean, it can be very messy when they start digging or investigating into these multinationals, and then they eventually find out that it's true that the breach came from their own part. So it's something, data protection and privacy is something that we should take very crucial in safeguarding the information of individuals and users alike, because somebody can be manipulated completely into divesting of all his safe funds from just giving his credit details to a platform, and that platform is breached. So it's something that is very important to both the users and organizations alike. Thank you very much. If there are any questions, we'd like to take them.
Okay, thank you very much, Lillian. And I'm very happy that you are very ready to take any questions that we have. And lastly, cookies. I wish all these websites actually giving us real cookies than telling us to accept cookies. All right, thank you very much. Okay, we'll just be taking a quick picture time before the question and answer session. I can see the weather is changing at our various locations. So I will encourage everyone to put on your videos for just 1 minute, smile for the camera while you are turning on your videos. I'll be taking some screenshots, which I'll be sharing after the session on our groups for our social media posts. Thank you very much, I could do so. Okay, I'm taking some screenshots. Thank you. We can see Mr. Solomon clearly now. All right, thank you. Okay. Okay, I've taken some screenshots. We'll be taking the question, and while I'm asking the question, mentors will also comment on both presentation. So I'll be taking the first question from Mr. Solomon. What really is the difference between data protection and privacy? Are they Siamese twins?
Can you hear me?
I don't know if you, yes, I can hear you. I don't know if you got that.
Can you hear me?
I'll be posting. Yes, we can hear you, sir.
Okay. So the question is on the what is it called? It's on the privacy and data protection, whether they mean the same thing or they are just mysteries. Well, I think I'd rather say they are more of being mysteries than being the same thing. One thing is clear. I think genetically or medically speaking, no twins have the same body composition and mental composition. So, and I've also come across situations where professionals, experts, scholars, use the words privacy and protection interchangeably. They do not mean the same thing, though they are very close. Now, for example, I think in the first group presentation, I saw them say privacy, some related privacy to informational privacy. Privacy has been even divided into about 5 categories. There is informational privacy, there is territorial privacy, there is bodily privacy, there is communication privacy. So, but when you look at data protection, for example, now there are instances where violation of privacy will not be violation of data protection. Let me give an example. Now, so for example, you under data protection, you have the right to accuracy of your data. Meaning when your data is inaccurate or inaccurately recorded, you can request that the data controller rectify. So let me ask Ezine. Ezine, are you with me?
Yes.
Can you hear me?
Yes, I can.
Someone told me that somebody is talking to you, and that's Joe Biden's son. And my spirit is telling me that you agree to marry the guy. If you agree to that guy, you change your surname from Iwu to Biden. So we have known you as Ezine Iwu, and now you want to bear Ezine Biden. Now, and all your public records in Nigeria has been Ezine Iwu. Now, when you are exercising the right, because it's a right, so the law says you have the right to have your personal data accurate, up to date. Is that correct?
Yes.
Now, if let's say a data controller says, "Oh, madam, we cannot change your name more. It's going to disrupt your system or our database." So, and you are saying, "Look, it's a right. I have the right to have my data accurate at all times." Now, if they now refuse to update to rectify your data, what have they violated? Your right to privacy or your right to personal data?
My right to personal data.
Are you sure it's not your right to privacy?
No.
You're very sure?
Yes.
Okay, so guys, she got it. Now, so another example. Let me see. Okay, great. Now, you go to a particular organization and your personal data is to be processed. And now, so they say, okay, so on your honeymoon in Vegas, okay, Nevada. So you guys have decided, even though you refuse to invite some people here, I know you're going to invite me. You don't have a choice. If you don't invite me, I will force myself down to Las Vegas. Now, so when you want to stay in the hotel, the receptionist says, "Okay, madam, you're welcome. Can we have your data page?" Now, and you're saying, "I want to know why you want to collect my data page. For what purpose?" And she said, no. You either give me your data page or not. And now you say, "Look, what you're doing here is contravention of my right to be informed." Now, under what category are you alleging a violation of your right? Your right under data protection or your right to privacy?
Privacy.
Final answer.
Yes.
Final answer. You want to call a friend?
No.
Okay. So Isaac actually knows the prospective groom. Biden's son. Isaac.
Yes, sir. I can hear you.
I know you know Biden's son, the prospective groom. So, and we need your help here. Is it a right or their right to privacy or their right to personal data that is being contravened in that situation?
A right to privacy.
Is that your final answer?
Yes, sir.
You want to call a friend?
No.
You don't even have a friend on this platform. We all have disowned you. Your body
No.
sold you because you get your money alone. So who else is in the room that has a contrary view? Anybody? Anybody? Yeah, my guy. Because you Kosola. Habana. So all of you have run away. Don't worry. Don't worry. Your Bible will say, Ilela koti joko dedi. You know what that means?
I didn't get your question. So my service was so bad. So I don't know.
So who is talking? Are you Kosola?
No, Chijioke.
Yes, but I
Okay.
didn't really get the question, sister.
Why will you get the question? When somebody is talking to you and you are responding to that person, you also want to go and spend honeymoon in Paris or Santorini because somebody is going to Las Vegas. Okay, so the question is this. Now, Ezine is getting married to Joe Biden's son. So they've gotten married and they are spending their honeymoon, in the most expensive hotel in Las Vegas. As we say, whatever happens in Las Vegas stays in Las Vegas.
In Las Vegas, yes.
I know somebody. Okay, so now they got to the reception, and the front desk officer said, "Can I have your data page of your passport?" And isn't it who is a data protection expert say, "For what, madam?" He said, "Please, can I have it? I need it." He said, "I need to know why you want to have it." He said, "No, you give me your data page or not." So somebody senses a right is being contravened in that situation. What right is being contravened? A right to personal data or a right to privacy?
It's her right to privacy because privacy helps you determine who has access to your data. So she doesn't want access to that particular data in her passport by the receptionist because they haven't given her reasons as to why they need it.
Okay, so who else who spoke
I
now?
think it's her right to data protection. I think it's her right to data protection.
Okay, who is that person talking now?
Chika Wonder.
Okay, Chika is one. Okay, yes. So Chika, you think it's the right to data protection?
Yes, I think so. Because privacy implies that there's been a breach of the information already, or there will be a potential breach. But data protection is preventing putting herself in that situation. So she's yet to release that information because she feels that she's protecting her data. The privacy will come in when the information is leaked or somebody has done something that would expose her personal information or private information.
Okay. So Chika, I want to go with you, but I would have loved if you had put it in a more accurate or appropriate form. So this is it. Now, Ezine is aware. I think she's actually caught up in the euphoria of a new life. I mean, married to the son to be the second. Don't worry. You guys don't know the feeling. You don't know the feeling. But then Ezine knows the feeling. So she's caught up in that euphoria. Because already, I am sure Ezine isn't going to object to giving them a data page. But what she's saying is that, please give me a reason, because the laws, my right says, you have to specify the purpose. And guys, you can remember, it was under principles of data protection that we talk about purpose specification. Is that correct, guys?
Yes.
Is that correct?
Yes, sir.
Yes.
Yes.
So
Purpose, specification, and
What
limitation.
is in the heart problem with? It's not the part that she's not going to. He's saying, give me a reason. Because whatever reason you give, you have to limit it to that reason or to that purpose. So, Ezine, let's come back to you. Are you in the room or you have gone there?
I'm here.
You are here. So the fresh breeze has blown into excitement. So which of your rights is being contravened? Your right to data protection or your right to privacy?
My right to personal protection.
Are you sure?
Yes.
Or you just want to agree with us so that you can go into the hotel room and lodge and spend amazing time and
No, I'm sure.
never take our course anymore. Okay, so it's your right to data protection. But there are instances where right to privacy will also mean right to violation of data protection. Now, it's not all instances where violation of one, during the past election, some of us just sat in our homes. Vote for Babajide Olusola Sanwo-Olu. Excuse me, is not a member of APC or any party at that. So how did somebody get a personality? I get a phone number. If something is worse, that let's say you live in a particular constituency, let's say Lagos West, you will just read something like Ezine, please vote for Adebule, so for Lagos West senatorial constituency. So you're wondering, and when you check out, you realize that the candidate they asked you to vote for is representing your constituency. So why didn't they say you another senatorial candidate representing another senatorial constituency in Lagos? That means they actually compare data correctly and they profile it with the for the electoral purpose. So in that situation, you can see that one, there is an unlawful access to your personal data. Then two, there's a violation of your right to privacy because sending that message to you, uninvited, unsolicited, is a violation of your right to privacy. Do we agree? Do we agree, please?
Yes, sir.
Yes, sir.
Guys, feel free to disagree if you have a contrary opinion. But trust me, there are instances where we have violation of one, constitutive violation of other. But it's not in all situations. So it will be wrong to say they mean the same thing. They do not mean the same thing. We can best call them twins. And I don't want us to call them Siamese twins. And I'll tell you why. Siamese twins naturally are inseparable. Privacy and data protection are separable. Because there are instances where violation of one may not mean the other. But they are twins because there are instances where when dad buys something want to buy something for one, for Peter, he may have to buy for Paul. When Taye wants to buy something for Taye, she will have to buy for Kehinde. So that's why then in the East, we call them Ejime. Is it Ejime? Is it Ejime?
Ejima.
Ejima, okay. So pardon my lack of accurate pronunciation. So when I want to buy anything for one of the Ejima, I think the natural phenomenon is that you buy for the two of them. But there are instances where James will pass, Peter will pass, Paul will fail. We have seen it with the P-square twins, the draw of P-square. One is rude boy, the other one is is Mr. P. We're told that one is actually rude, the other one is more courteous. So they are twins, but definitely not inseparable to it, not semesters. I hope that takes care of that question.
Thank you very much, Mr. Solomon, for that example and that explanation. I'll be taking the next question for our second mentor. What is the best method or approach to appreciate and study data protection and privacy?
Okay, it's good to be back again. And in trying to appreciate and have a very good understanding about data protection and privacy, you must know that there's actually the theoretical understanding and also the practical application. And when you have this both, you rest assured that you are building a very good foundation. And how can you achieve the theoretical understanding and the practical application? First, you must educate yourself. So apart from having this platform where you learn on your own, you must build your own understanding by reading books, engaging in research work, and also reading other people's research papers, then reading articles on data protection and privacy. Also, you have to stay updated. As you can see that data protection and privacy laws and regulations are constantly updating. So we just move from living in regulation to having an act where enforcement is very, very obvious. So it is constantly updating. So you must keep yourself updated as well. You must stay informed with latest development and changes in the regulations. So this will help you, and this will give you that appreciation of the whole concept. And thirdly, I'll say taking trainings, just like what you're doing right now. You don't stop learning. You don't stop learning. After this, make sure you still get yourself involved in other trainings and as well train others. This will enhance your knowledge. This will give you more appreciation to the whole concept. As I said earlier, practical application is very, very important. As you can see, Mr. Solomon is always bringing in practical approach. And from his practical approach, you will be able to have this sense of understanding of the concept, just like the scenario he gave earlier about the request for personal information now by the hotel. As you can see, on the other hand, you can visualize that answer coming from the aspect of privacy. And on the other hand, you can actually think out something out of data protection. Now, I appreciate the answer Mr. Solomon gave, because privacy is a more and more wider scope compared to data protection, because data protection is very straightforward. But when you look into privacy, you are going to go so deep that you will discover so much more. And lastly, I would say you should also engage in discussions. Engage in discussions with persons that are in this field. They will help you understand better. And get acquaintance with people here, and make sure that you keep that relationship going. Keep the talk going and keep the networking going. This will help you so much. And I'll say that this is a good foundation for you, and be rest assured that you are about to make a great impact on this very field. Thank you very much.
Okay, thank you very much, Mr. Emmanuel, for that answer. The last question, I believe, has already been answered, which is the introduction of Mr. Solomon Okedera today, but I'm just going to ask it so that he would still elaborate more on it. What is the current data protection and privacy law governing Nigeria?
Okay, so I think are we still commenting on the presentation? Or
Yes, sir. Yes.
So because in fact the only let me say this, the two groups did an amazing job. I mean, just like Mr. Emmanuel said, this is a foundation, and trust me, a good foundation for the two groups. The very best you can do is to keep building on it consistently till someday you wake up, you realize that you are giving myself and Mr. Emmanuel a run for our money, and yeah, you are making us decide that look, if guy is not taking these folks will soon displace us. So I think I have a comment. So should I just go into the comment of the presentation by the first group? In fact, that's the only comment I have. They had a good presentation. So should I just go ahead?
Yes, sir.
So please, who presented for group one?
I did.
Who? What's your name?
Isn't it?
Isn't it you? You. Isn't it? Where did you leave NDPR, Nigeria Data Protection Regulation? Where did you leave it? Joe Biden cannot save you here.
No, I was
when
confused. I was confused as to the status of the NDPR with the enactment of the Nigerian Data Protection Act. So I even asked the question here because I wasn't sure.
Yes, and you are not the only one confused. Many people are confused. Many people will be confused. In fact, some judges will be confused. So your confusion is not a bad thing. Don't worry. Now, if you pick the NDPA, it does not repeal NDPR, right? As a matter of fact, what it does is that it's transitional provision, which I think is section 54 or something. Now, what that section did is actually to save all of the guidelines, provisions under activities of Data Protection Bureau, Nigeria Data Protection Bureau, NDPB. Now, as it's becoming, or it has become Data Protection Commission, every other thing it has done is in order. That's what it has said. Now, so it did not say anything about NDPR. And can we say NDPR has been repealed by necessary implication? No, I do not think so. So, because when you look at it, now for you to have it repealed by necessary implication, then you now need to consider what are the provisions of the NDPR, then what are the provisions of the NDPA. Though I believe, quite frankly, that that's an error. Trust me. And sometimes some people will need to approach the court. But as of today, NDPR is actually an extant regulation, data protection in Nigeria. As a matter of fact, as I am on this session, I am preparing a process based on NDPR, and God forbid that NDPR has been repealed. You know what that would mean to me? That case will not be able to be filed because that situation happened before the advent of NDPA. So, and I cannot rely on NDPA for a violation or contravention that happened in February 2023. Or can I do that? Talk to me now. At least we now belong to the most powerful family in the world. Talk to us. Let us know. Eh?
No,
I cannot. So that's the point. So that's why I'm saying, God forbid that, in fact, I think maybe because of me, that they made that error. Because I'm going to call on NDPR now. I also love to give you guys a question. And that question is, when you need to seek a redress, which court will you go to now? Can somebody answer, which court will you go to seek a redress for your rights under the NDP? Okay, so let me, while you are thinking about it, maybe you want to call a friend. Let me just add my comment to the second group's presentation. I don't know whether how detailed Mr. Emmanuel's review will be, but trust me, I think these guys did well. The only thing is that the second group, who presented for them? Can I have the name?
Lillian.
Who?
Lillian.
What do you call the name?
Lillian. Her name is Lillian. She was the one signing out today.
Lillian, right?
Yes.
Lillian did well, amazingly well. The only thing Lillian did, at some point, Lillian confused me. Lillian said Section 37 of the Constitution provides for right to privacy. Then later she said Section 35. I don't know whether she's relying on the 1999 Constitution or 1979 Constitution. That is the only thing pretty much I think I need to clarify. The Ezine, you did well. You also mentioned data minimization. I think about 2 of them that I skipped. But by and large, Mr. Emmanuel also give his comment. So an assignment I will give you guys, tell me which court I will approach when a data controller has contravened my right under the NDPA. Which court? Do you know? If you don't know, let me know. So, Mr. Emmanuel, please take the floor, sir.
Okay, thank you very much, Mr. Solomon. And I would like to join my voice with yours and say that the first presenter did a very good job. And they have a very beautiful slide, really beautiful. And I would say that they have done well, but I'm not really satisfied with the level of information that they have provided, because it will not really help your foundational knowledge. Like I was expecting more details in understanding the key concepts, like understanding. Let me give an example with the data subject. If you're talking about a data subject, who you're supposed to give more details, not just the person whom the personal data relates to. So there are other questions like can a dead person have personal data? Now, can a corporate body have personal data? We want to know more about this. Expand the scope so that you will have very solid knowledge about the whole concept. So that's just my observation. So if you can do more on this certain concept, understanding them in-depthly, it will help give you a very solid foundation. Then for the second presenter, excellent job. Very good presentation as well. And I'd like to say your slide as well is so beautiful and really catchy. So very good job. Well done.
Okay, thank you, Mr. Emmanuel. I think there's another thing I skipped, but maybe because I just want to be mild with them. And that is the fact that they also, just like the previous said, have not actually made use of case law. Yes, we may not have enough decisions yet, particularly local decisions, but we have foreign and we still have some. And I want to be sure that from the middle of next year, we will have a number. A number. In fact, I know already from maybe June next year, you have Solomon Kedara and Attorney General of the Federation, some Kedara and INEX, all of that. I have so many other. And I want to be reading cases in the names of participants in this room. Please, I want to be reading them. So that's on that note. Does anybody have a response? I mean, you guys have taken into consideration Mr. Emmanuel's suggestion. Then does anybody have an answer to the court you will approach when your right to personal data is violated under NDPA?
There's an answer in the chat box.
Okay.
By Chijoke. Chijoke.
She said the NIC or the High Court. I don't know. Is she asking a question? There's a question tag in front of the.
I think that
I have a question.
I think that the answer would depend on the circumstances of the case and the parties involved.
Exactly.
Exactly. I like that. Exactly. So, exactly. So, can I go to customary court?
It will depend on the parties involved.
Okay, what kind of parties will you go to customary court? What about area courts?
Well, from what I know about right enforcement actions, for example, the FREP, generally FREP actions now are usually instituted at the high courts. So that is why I was of the opinion of either the High Court or the National Industrial Court. Why I said the National Industrial Court is because you'll be instituting such actions against corporations, companies, and those actions go to NIC. That's why I'm sort of conflicted, and I agree that it depends on the circumstance of the case.
I think at NIC, you'll be talking about maybe labor or employment or union rights and all that. Then for the High Court,
who is speaking now? Chika.
Yes.
But I can go to customary court.
Yes, you can go to customary court, but it would depend on the issue at hand, on the case or what.
Customary court is not a court of record.
It's not a court of record, but it depends on the case. There's still privacy.
Can I go to a tribunal?
Yes.
Like investment tribunal?
Yes. I think so.
So I can go to any court actually, Abi?
No, you can't go to any court. It will depend on the parties involved, like I said.
Chika, can I go to any court?
No.
Not
just any
you
court.
said I can go to a court. I can go to NIC. I can go to customary court.
It will depend on the parties involved.
Yes, depending on the party, I can go to any court.
Yes.
Is that correct?
Yes.
Is that what you're saying?
Yes.
Okay. Who has a different opinion or who shares same opinion with a robust explanation? Okay, so let me ask this question. Does the law, the NDPA, does it specify a court you can go to?
No, sir.
It does not. Is that in order or it's not in order?
It's not in order.
Okay. What? Let's wait to see what court will say. So we have the case already. Solomon Sidara and Nathan Jerry of the Federation. So we are waiting for what the court will say. I have said subject matter legislation like Data Protection Act must specify court with subject matter jurisdiction in the matter. Specific subject matter legislation always specifies court with subject matter jurisdiction. For example, the Freedom of Information Act specifies High Court or Federal High Court. The Cybercrime Act specifies the Federal High Court. What it means that when you have a matter or burden of federal freedom of information, you cannot go to a customary court. Can you?
No, sir.
So, but we can go to customary court for data protection matter, right? Can we? Say your mind now. Let the devil be ashamed. Eh?
No, sir.
Okay, so guys, don't worry. Like I told you, in this room, do not feel bad. Do not feel ashamed to say what you think is right. You may be right ultimately, and you may be wrong ultimately. The good thing is that even when you're wrong, you're going to get the right answer, and you're going to be better for it. For me, I believe strongly poor legislation. It's a poor draft, drafting skill exhibited in that situation where you see Section 65 of the Nigeria Data Protection Act provides that a court under this law will mean any court of competent jurisdiction. Any court. So when you guys said customary court, I'm not surprised. You didn't cause it. NDPA causes it. He said any court of competent. That thing doesn't mean anything. Before you can even use, if they have said any court, maybe it would have been better. But saying any court of competent jurisdiction implies something, that a court that can entertain this matter will be a court that has competence to entertain it. Now, but you cannot use the phrase any court of competent jurisdiction without first specifying such court with competence on that matter. So that may be worse. Like I said, if they have just said any court, we know that they want us to go to any court. But when they said any court of competent jurisdiction, that's when they have actually scored on goal. They have said that court, and it will have to be any court that has competence in entertaining matter or adjudicating data protection matters. So we now have to go to what makes a court of competent jurisdiction. One, it has to be duly constituted. If it has to be by a court, by one judge or two judges, whatever it is. Two, it has to have subject matter jurisdiction. Three, there must be nothing that is preventing that court to exercise its jurisdiction. So the question again is that, do you think a customary court or area court has subject matter competence on data protection matters? And before you answer the question, some of you smartly brought it up that, look, data protection is an extension of right to privacy. Right to privacy matters are only tribal at high court, federal high court, high court of state, high court of FCT. Then data protection matter in that situation cannot be by any court, but by specified court under that act, just as it applies to subject matter legislation like Freedom of Information Act and Cybercrime Act. What thou do I have to say? Any contrary view? Any contrary view? Waiting now. Hello?
So does it mean
what? Why did you guys just go quiet?
So does it mean like that, driving from the point that data protection is an extension of right to privacy?
Yes.
And right to privacy is the fundamental human right as provided for in the Constitution. And
yes,
actions for fundamental rights enforcement are brought
Only under
before
the
the High Court. So should we now derive from there that a competent court is now the High Court?
In fact, my own argument to the court in this case is that it should be, I've asked the court to assign the meaning of court of competent jurisdiction in the act to federal high court. And I gave 3 reasons. One, matters of data protection are matters of privacy, and privacy matters are only tribal by those courts, number one. Number two, I have said that, look, using a phrase of any court of competent jurisdiction implies that the court will first of all have competence. So which kind of court will have competence in data protection matters? It will be a court with expertise and experience. Magistrate court will know the ICC is constituted. The moment you are 2 years at the bar, you can become a magistrate. Now, do you think a magistrate of a judicial officer of 2 years has enough experience and expertise in such matters, fundamental human rights matters? Why is it that fundamental human rights matters are not being adjudicated at the magistrate court or customary court? Number 3, data protection legislation across Africa, particularly that is cited Ghana and Kenya. They are being litigated at the High Court. So those are my 3 reasons why I believe. Now, you see, what the draftmen did was that they played the smart one, but they do not realize that playing that smart one is not. In fact, in one of the lines in my written address, I said that using the phrase "any court of competent jurisdiction" is nothing but mere fanciful phrase, because it doesn't mean anything. It doesn't mean, you see, it can only mean something if you have listed courts that have competence entertaining data protection matters. But if you have not listed them, then how do you want us to know any court of competent jurisdiction? How now, Oluwami, my lord? How?
Well, I have one sort of an understanding of, as much as that section was ambiguous, it was very ambiguous of them. They should have been more particular about it. But then they said it must have the jurisdiction, it must be competent for it to hear such matters, right? And from what we understand about, like, there are forms of jurisdiction: subject matter jurisdiction, territorial jurisdictions, and constitution of its members and all that. So we can as well say that if a particular court has, if you check out the, like, by number of its judges and all that, if all those ones are there, then we get to subject matter. I believe it just borders on subject matter now.
Yes.
We have to determine, for that court to have competence to hear that matter, we must determine if it has that subject matter, if it can hear matter.
So the next question we now need to ask is that matter jurisdiction donated. Should I give you that as assignment? But let me help you out. The position of our court has been that subject matter is jurisdiction is donated by the constitution or a statute. So a statute has to donate subject matter jurisdiction to a court. A court cannot even assume. It cannot, parties cannot say, "Hey, my lord, we submit to your jurisdiction. We want you to adjudicate and entertain this matter." The courts have said no, it's not possible. It has to be specified by the constitution or a statute. So what will be your response to that? Chijoke.
Yes, I'm here. I'm thinking.
Talk to me now. Is it because I sounded like that? Talk to me now. How far now? Eh? Your voice has gone down now. Why? Is it because my own voice went up?
I'm still.
It's not expensive, but that's actually the law. That's the law. The law says subject matter. If you want me to refer the what is it called?
No, I agree with that. It has to be established by a statute or the constitution. Yes.
Because if you don't do that, there will be what is called legal riotous legal adjudication or jurisdictional conflict. Somebody will go to area court in Nasarawa to litigate data protection matter. Some other person will go to customary court in Kenya. Somebody, now at the end of the day, because those courts are courts of summary jurisdiction, you will even have more judgment from those courts before you before you have court of federal. So we cannot have such a system. But you see, we don't have a problem. The draftsmen created the problem for us. For whatever reason they were afraid of, whatever reason they thought they were trying to be smart, they were not smart. Because they should have had recourse to what have been the pronouncements of the court. If the court have said it is only the constitution and the statute that can give subject matter jurisdiction, you cannot now say any court with competent, any court of competent jurisdiction. You cannot say that. That thing, like I said in my written address, is a mere fanciful phrase. It means nothing. Particularly without earlier specifying or listing or mentioning courts with such competence. Any contrary view? Isaac.
I can hear you, sir.
Isaac. Why am I dragging Isaac today like I'm dragging I passed my neighbor generator? Well, you know you're my guy. Isaac, you know you're my guy.
Very, very well, sir.
Okay, great. So do you have a contrary view?
I don't.
You don't.
I,
You don't want me
don't.
to remember me another money you're owing me.
So, I agree with the views. They are sound.
Okay, great.
Isaac is owing me too.
Sorry?
They are very sound arguments, sir.
They are sound arguments.
There are some arguments about, so what do you think is the way forward? Do they need to amend the constitution or create a statute to establish a court to entertain subject matters such as data protection? Or they need to
amend the Data Protection Act?
Exactly.
The recommendation.
Hello, sir.
I think we lost Mr. Solomon. So we can't hear you. Let's just give him a moment to join the call. We can't hear you, Mr. Solomon. Okay, he left the call, so. Mr. Solomon is not back on the call. I think he's having a network problem. And we've passed time for today's session. I believe we can all continue from where we stop on our next session. With this, we've come to the conclusion of today's session. I hope all our mentees enjoyed. He's back.
Hello.
Okay, you are back, sir.
Can you hear me?
We can hear you now. Yes,
yeah,
sir.
I'm sorry. I went off my computer. I didn't plug it. So I'm using my mobile right now. And so clearly, to respond to the question asked, the World Bank actually recommended specialized courts to be created for data protection matters. And trust me, guys, let me say this and be prepared for it. Data protection will spring up the highest number of cases we ever have, because that is actually one area of endeavor that there will always be violation every day, day in, day out, all over the world. So we actually should have, there shouldn't be a problem if we have specialized courts. But if we do not have, then we actually need to have courts that can really entertain such matters. Why we need more courts? We at the same time we need courts with expertise. One of the reasons why we talk about specialized courts is to actually bring expertise and experience in the subject matter. So in the meantime, I have actually asked for some relief from the courts. The first relief is that the court has the power to assign minutes to any court of competent jurisdiction. And that the only minute the court should now assign to it is the fact that, look, it will now mean Federal High Court, High Court of State, and High Court of FCT. Then I have also asked the court to, I've asked for a consequential order directing the National Assembly to immediately amend the act to now repeat specific court with subject matter jurisdiction under the act. Then I've also asked for a further order for the second respondent, which is the first respondent, which is the AGM, to be directed to liaise with the National Assembly to amend that act. That's where we stand as a people. But to leave it open is going to lead to a riotous legal adjudication. Every victim and Harry will begin to entertain. And that's one thing. Then two, when an objection is now filed, even before a high court, somebody can say, look, it is federal high court that has jurisdiction. Then some other person will say, a high court may agree. That's a fact. What if a magistrate court agrees and a customary court believes that, look, I have jurisdiction? It is any court of competent jurisdiction, the law says. We're going to have the jurisdictional conflict. We're going to have riotous legal adjudication, and we're going to have miscarriage of justice. So hello guys, I hope you got my view.
Thank you very much for that answer. I hope it answers our mentee's question. If you're on the call, you can just respond to Mr. Solomon before we leave for today. Okay, Mr. Solomon, thank you very much for making out time to mentor us today. We are so excited to learn from your vast knowledge and experience. Mr. Emmanuel Erere, thank you very much for always making it and always coming to JIIPCC's aid. Thank you very much. Special thanks from my boss, Miss Juliana, to our both mentors. I will say a very big thank you to also the presenters for today and also the group leaders. I believe the group leaders did a very nice job to coordinate the research and also make sure that your PowerPoint presentations are ready on time. Thank you very much for the job well done. We'll be meeting same time, 5 p.m. next week for the next week topic. Thank you very much, everyone, and have a lovely night. Bye-bye.
Bye-bye, guys.
Thank you, Mr. Hussein.
All right.
Bye.